And joining me now to discuss the case involving Luigi Mangione is Jeremy Rosenthal, trial attorney, founding partner of Rosenthal, Kalabas, and Therian. So first of all, thanks for coming on the show. His most serious charge is second-degree murder. What kind of evidence do you think would prosecutors need to charge Mangione with first-degree murder?
New York law requires that there be a little more evidence of something like terrorism. The way that a murder law tends to work is that it's all based on the intent. And what states do is they sort of cobble together, based on things that happened in the past, they add things that are aggravating factors which bump it up. For instance, the death of a child under a certain age. When these things happen, the legislature looks back and says, well, we need a law to fix that. Or if it's a hate crime based on the person's identity or based on a racial identity or what you would call an immutable characteristic, then the law is going to bump it up like that. The issue here is that there's no law currently on the books that says just because you kill somebody of significant social significance or because he's an insurance executive, that doesn't necessarily get you there. So what they're trying to do prosecutorily is they're trying to figure out a way to get him on a first-degree charge. And the closest thing they could do would be if he's got sort of a motive that you can sort of link together, kind of almost like a terror situation, that could allow them to prosecute it as a higher offense.
So then for second-degree murder cases, what do you think defense might look like for Mangione?
For second degree, the first thing is that we have to consider is he's looking at a lower sentence range, not by much. First degree murder in New York State is going to carry 20 years to life. Second degree murder is 15 years to life. What second degree murder does, though, that's really important, is it unlocks a handful of defenses. And to kind of go back about how murder laws are sort of written and how they work, always follow the intent element. The intent is always what's going to dictate what is a higher charge from a less high charge, right? When somebody, for instance, is planning for months, faking IDs, printing a 3D gun, taking all these premeditated steps, obviously the intent's going to be here. If it's a car accident where somebody dies, or to go back to Daniel Penny, to his case, right, the intent was much lower at its worst, right? They were alleging what you would call manslaughter or criminally negligent homicide. When you're charged with second-degree murder in New York State, you can argue a lesser intent was there, and one of the defenses for Mangione could be this was just manslaughter. So he might not be able to get a complete defense out of it, but it unlocks certain other defenses that could help him in the long term.
Do you think Mangione's defense might explore an insanity plea? What would they do in order for that to succeed?
Insanity is really hard to do. Of course, if you're defending this case, you look at every option that you could possibly look at, and you want to give your client as thorough defense as you can. The problem with insanity is that insanity, which gets confused a lot with what we call incompetency. Insanity means, to some degree, I didn't understand what I was doing was wrong. So in essence, it has to be something like, I thought that I was shooting a space alien or something to that effect. It's got to be that degree of severity. It's got to negate or rebut, if you will, the intent element, right? I thought I was doing okay because I am so disturbed that I thought my actions were fine. That's an insanity defense, and the facts here don't seem to lend it to that, but certainly you would expect as lawyers to maybe kick that tire a little bit.
All right, I see. Let's explore this a little bit more. Do you think federal prosecutors might decide to step in and charge Mangione? Under what circumstances would that happen?
I think anytime you've got a murder case, I think that most federal prosecutors are going to default to that jurisdiction. They're going to want to make sure that the victims in the case, the family, is addressed, and they're going to want to do that. So I would expect it at default to New York case. If they have problems or issues there, there's a whole host of things that you could probably investigate and prosecute Mangione for: crossing state lines, having an unregistered weapon, printing a 3D gun, and anything and everything that they can do, they could probably do that. And let's say, for argument's sake, Mangione does get a much lighter sentence than the feds would like. In that point, they might step in. But I think they would probably, I think everybody here defaults to New York State and what they want to do there.
And let's talk about the evidence in this case for the manifesto and the 3D printed gun. I mean, are there any challenges you see in presenting them as evidence in court?
You can try to throw whatever roadblocks you'd like in front of these things. It's going to be hard. I mean, these are all things that that sort of help build this circumstantial case, if you will. You can try to keep the manifesto out. You can try to keep some of those other things out. If you're a prosecutor, you're arguing that this establishes the motive, that this establishes the animus, right? A motive is not an element of a case. The prosecution does not have to prove a motive, but it really helps. It helps the jury understand it. And most judges are going to think that that's relevant. You can try to throw up these roadblocks. That's what effective defense lawyers do. We kind of knock over every fruit stand and push shopping carts in the way of the monster. But the monster, in this case, probably gets him.
All right, Jeremy, that's our time today. Thanks again for coming on.
Always. Have a good day.